Hello friends, in the series on the income tax cases, today we will discuss a case on section 148 in which there came before the court three very important issues regarding the burden of proof, onus of proof, shifting of onus of proof and whether the Evidence Act is applicable to the income tax proceedings. This issue has come before the Honorable Bombay High Court in the case of Prabhat Properties Private Limited versus Assistant Commissioner of Income Tax and others, and this case has been reported in 461 ITR at page number 390. The date of the judgment is 27th June 2023. Friends, I have seen that Bombay High Court is very strict in those cases where the assessment has already been completed under section 143 subsection 3 and again the department want to reassess that income under section 148. In the present case, the assessment of the assessee was completed under section 143 subsection 3. The assessee was claiming some exempt income under section 10 subsection 38. SEBI has given a report to the income tax department that some trades have been reversed and there are some accommodation entries which have been taken by the assessee. When this information was received by the income tax department without having any tangible material or without establishing the live link between the information received from SEBI and the particulars of the assessee, without establishing any live link, issued the notice to the assessee under section 148. The assessee raised detailed objections for the issue of the notice because the assessment of the assessee was already completed under section 143 subsection 3, but the assessing officer, without going into the content of objections, dismissed the objections. The assessee filed a writ petition into the Bombay High Court and the main contention of the assessee was that it is a matter of change of opinion because the assessment of the assessee has already been completed under section 143 subsection 3 and it was the contention of the assessee that whatever the objections have been raised by the department, whatever the objections have been raised by the assessee, those objections has not been disposed in a right perspective by the assessing officer. When this matter was heard by the Bombay High Court, the Bombay High Court said that according to section 103 of the Evidence Act 1872, the burden of proof to any particular fact lies on the person who wishes the court to believe in its existence unless in the law itself it is mentioned that the burden is on the person. The court also said that according to section 101 of the Evidence Act, the burden of proof lies on the person who asserts the affirmative of the issue. The court reminded about the difference between the burden of proof and the onus of proof. According to the Bombay High Court, the burden of proof is fixed. Once there is a burden of proof according to the law on a person, then he has to prove beyond doubt. But until and unless there is a concept of burden of proof in the Act, there is a concept of onus to prove. Onus to proof always keep on shifting in the evaluation of the evidence. Meaning thereby that if some allegation has been made on the assessee on the basis of some material and the assessee has raised its objections, then without disposing of those objections point-wise, the department cannot go ahead with the issuing of the notice and with the assessment until and unless the assessing officer relies himself about his onus to prove those documents not correct. Because in the present case, the assessee has given all the evidences both at the time of the original assessment under section 143 subsection 3 and again at the time of raising the objections. But the assessing officer, without giving any heed to those objections, plainly rejected those objections and go ahead with issuing the notice under section 148 and completing the assessment. So the assessee objected this assessment in between and went to the writ court, and the court quashed both the notice and the order disposing of the objections, which was not as per section 103 and 101 of the Evidence Act 1872. So friends, there is very much importance of section 103 and 101 of the Evidence Act in evaluating the evidence which has been submitted by the assessee at the time of assessment proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is Prabhat Properties Private Limited versus Assistant Commissioner of Income Tax and others, and this case has been reported in 461 ITR at page number 390. The matter has been decided by Bombay High Court and the date of the judgment is 27th June 2023. Thank you friends.